And thank you, by the way, all for coming this morning. We're going to talk about the ObamaCare exchanges, and that is a big subject with many moving parts. So I just want to, by way of introduction, take a step back and place this issue in context, and talk about how the exchanges fit into Obamacare as a whole. So, of the many problems that we've seen with the Affordable Care Act, perhaps none has been more harmful up to this point than the arbitrary enforcement of the rules and regulations by the Obama administration. And we see this from the suspension of the employer mandate back in July to the recent announcement that those whose insurance plans were canceled because of the ACA can now qualify for an exemption from the ACA. And we see this whenever public outrage kind of rises up over some unintended or intended consequence of the ACA, or whenever it becomes clear that some part of it will be unpopular or unworkable or difficult, the administration has attempted to change the law by fiat. And so one never knows what will change next or how it will change. Now, why is this happening? In The Road to Serfdom, Friedrich Hayek argued that this kind of arbitrariness is inherent in any law that interferes with the economy in order to determine outcomes. There's no other way to implement a law like the Affordable Care Act. So in a democracy, the legislature can lay down rules with indeterminate outcomes. That is all they can do. Legislatures limited to the making of rules, any number of outcomes are possible in a free society. Only an unfettered executive can implement a regime that attempts to impose a single defined outcome. And it can do so only through the arbitrary use of the administrative and bureaucratic state. If you want to determine outcomes, the rules themselves must be infinitely changeable. And we see this. We see this playing out in the implementation of the ACA. The law's interference in our healthcare system and in the US economy at large has resulted increasingly by government that rules through administrative decree and a corresponding erosion of the rule of law that implies and that accompanies that. And this arbitrariness was the inevitable result of a law that was itself designed to produce a determined set of outcomes and that improperly looked to the apparatus of the administrative estate to achieve this end. Now, according to Hayek, the rule of law means, this is his quote, that government in all its actions is bound by rules fixed and announced beforehand, rules which make it possible to foresee with fair certainty how the authority will use its coercive powers in given circumstances and to plan one's individual affairs on the basis of this knowledge. And by this definition, the administration's enforcement of the Affordable Care Act amounts to something less than the rule of law. Of the more than 30 significant changes to the law we have seen over the past year, nearly half of these have been enacted unilaterally by the Obama administration without congressional authorization. Individual Americans cannot plan their affairs around the capricious regime of the ACA because it is clear that the administration is willing to delay, suspend, rewrite whichever parts of the law it finds expedient. And that brings us to the exchanges. This phenomena is nowhere more apparent than in the creation and the implementation of the health insurance exchanges. Over the past year, we've seen a lot of changes to the exchanges, and I'll just run down a few of the highlights. These are by no means all of the changes we've seen, but in March of last year, the Small Business Exchange was delayed until November 2014. Over the summer in July, there was the announcement of the employer mandate delay. But there was another announcement in conjunction with that, and that is that exchange applicants were allowed to self-report their income without verification, applying for tax credits and subsidies. In October, the individual mandate was delayed until the end of March this year. In November, the administration announced it would not penalize non-ACA compliant plans that were being canceled by the millions and continue to be canceled, and said that state insurance commissioners should allow carriers to continue offering non-compliant plans. And then last month, the administration expanded the hardship waiver. This was a waiver that was originally designed to allow some people to purchase catastrophic coverage, and the administration decided the waiver would apply to anyone who has had their plan canceled because of ACA regulations. And perhaps the greatest administrative change so far has been an IRS rule that attempts to dispense premium assistance tax credits in the 34 states that have refused to set up an exchange, and Texas is one of those 34. Under the ACA, these tax credits directly trigger penalties against employers and indirectly against individual taxpayers. The IRS rule, therefore, has the effect of triggering spending and imposing financial penalties that Congress never authorized. Now, this rule has provoked a number of lawsuits. To date, 4 have been filed challenging the rule: Pruitt versus Sebelius, Halbig versus Sebelius, King versus Sebelius, and Indiana versus the IRS. And Mr. Carvin is going to talk to us about Halbig versus Sebelius here in just a few minutes. Ironically, the many arbitrary changes to the law have not included reasonable measures to regulate so-called ACA navigators. These are the people who have access to personal information that individuals submit to the exchanges for tax subsidies and to get their health insurance plans. States have been left to their own devices in this regard, and some, like Texas, have begun to take steps to protect their citizens, and Commissioner Rathgaber will speak to that in a moment. Meanwhile, businesses and individual Americans are left wondering how best to order their affairs to comply with a law that seems to change with each passing week. And Ms. Parker here is going to talk about the exchanges and compliance from a business perspective and what businesses are doing to deal with this changing law. I'm going to introduce each one of the panelists one after the other and then have them come up and give remarks. At that time, we'll open it up to questions and discussions from you all, and there's a microphone in the middle of the room to help you with that. Michael Carvin is a partner at Jones Day, where he focuses on constitutional, appellate, civil rights, and civil litigation against the federal government, and has argued numerous cases in the United States Supreme Court and in virtually every federal appeals court, including the recent constitutional challenge to the Affordable Care Act. He is was one of the lead lawyers on behalf of George W. Bush in the Florida recount controversy during the 2000 presidential election, and has represented state governments, financial institutions, telecommunications, and energy companies in takings, First Amendment, civil rights, and statutory challenges to federal government actions. As I mentioned, he's the lead attorney for the plaintiffs in Halbig versus Sebelius, which challenges the IRS's authority to issue hundreds of billions of dollars in federal subsidies to health insurance companies and to impose penalties on taxpayers and employers in those states that refuse to set up an exchange. Becky Parker here, to my right, is the Health Reform Director at MHBT Incorporated, Central Texas's largest privately held employee benefits specialization group. She directs all corporate strategy and communication pertaining to the Affordable Care Act for MHBT and its clients, and has worked as an employee benefits advisor since 1992. She's an active member of the Austin Association of Health Underwriters, where she was president in 2003 and received their highest honor, the Shirley Hutzler Award, in 2004. She also served on the Texas Association of Health Underwriters Board as their liaison to TDI and was honored nationally for her work. At the end of the table is Julie Rathgaber, who was appointed Texas Insurance Commissioner in May of last year by Governor Rick Perry, and the appointment was confirmed in June of 2013 by the Texas Senate. Commissioner Rathgaber previously served as Deputy Chief of Staff in the office of Lieutenant Governor David Dewhurst, and is a past Director of Research for the Texas General Land Office and a past Director of the Strategic Assessment Division for the Texas National Resource Conservation Commission, which is now TCEQ. A member of the State Bar of Texas and the Seton Fund Development Board, and a volunteer supporter of the Settlement Club and the Settlement Home for Children. Please join me in welcoming our panelists this morning. We'll start with Mr. Carvin here.
Yeah, thank you. I'd like to start with discussing the lawsuits that John mentioned. I'm actually lead counsel in the Halbig case, which is pending in the D.C. District Court, and the King case, which is pending in the Eastern District of Virginia. The Oklahoma case is also going. That's about 6 months behind us, probably, and then the Indiana case has really not gotten very far yet. I was hoping I'd actually have some news for you in terms of having decisions by this time. We are, both in Halbig and King, the judges said they would give me decisions by the end of the year, but they treated that deadline like the Obama administration treats the Act's deadlines. But I I really think we're going to get a decision any day now. I suspect next week or the week after, and we will be able to then immediately appeal if we lose, or the government will immediately appeal if we win. And so it should get resolved, I would think, by mid-year, hopefully, or the fall at the latest by the appellate courts, and then if it's worthy, it'll be on the Supreme Court's docket for the following year. So what's at stake here? What's this case about? The net result of this case is very, very important. If we prevail, 36 states will not have any subsidies on the Obamacare exchanges. More important, they will not have any employer penalty or mandate that employers provide the insurance required by the Act to their employees. The legal reason for this, normally when I discuss these cases, I like to go on at length about nuanced issues of the First Amendment or the Commerce Clause and all of these. Literally, the legal issue in this case is, does state mean state, or does it mean federal government? To the non-legal mind, the answer might seem relatively obvious. No, state can't mean federal, but that is literally what the IRS and the administration is arguing. So what does it mean exactly? In the provision of the Act that determines when you're eligible for a subsidy, it says very clearly, you are only eligible for a subsidy if you get your insurance through an exchange created by the state under Section 1311 of the Act. And the government wants the courts to accept the notion that that means if the exchange was created by the federal government under Section 1321 of the Act, they will still get these subsidies. And the other important point is, for some reason, the Act linked the employer penalty to one of the employees going on to the exchanges and getting a subsidy. In other words, you didn't have any requirement as an employer to provide health insurance unless and until one of your employees went on the exchange and got a subsidy. Then you had this requirement. So if we are correct that it's only the state-created exchanges where you have subsidies, that means it's only the state-created exchanges where you have the employer mandates. And in the wake of the Act's enactment, 36 states have said, no thanks, we don't really want to get ourselves involved in the business of running these exchanges. And as a consequence of that, if we prevail, again, there will be no subsidies and no employer mandates in those states. I won't bore you too much with the arguments for why state doesn't mean state, because you've all got IQs in 3 figures, and I don't really want to belabor these points, but their basic argument is as follows, is that in the provision that allows the Secretary of HHS to form an exchange if the states default, it says the Secretary shall establish such exchanges. So they say, well, see, since the Secretary is creating the same exchange as the state would have created, this creates a legal fiction that the federally created exchange is the state-created exchange. And we make the following points, which is, that provision allowing HHS to create the exchanges is only triggered if the states fail to create the exchange. The subsidy provision says you only get subsidies on a state-created exchange. Moreover, a federal exchange in place of a state exchange, by definition, can't be a state-established exchange. So none of this really works, and they understand that, really. They know the language doesn't help them, indeed kills them. So their main argument is, it would be unthinkable to have 36 states without subsidies and without exchanges, and Congress surely liked all of these subsidies and all these penalties, so just ignore the language and do what Congress would have wanted you to do. And our response to that is, all they did with the exchanges was exactly what they had done with Medicaid. In other words, they knew Medicaid, they couldn't force the states to spend money on Medicaid. And they couldn't force the states to run the exchanges. But for a lot of political reasons, mainly that Senator Nelson at the time insisted that the states run the exchanges, they knew they had to offer a very powerful incentive to get the states to take on this job. No one thought running these exchanges was going to be a lot of fun or politically popular, and the states got nothing out of it. they just got all the hassles that we've seen have occurred in the last few months. So Congress knew it had to give the states a really large incentive to take it over. So they made them an offer they couldn't refuse. It was the same offer they made when they were trying to coerce them to expand Medicaid. They say, if you don't take this deal, we will cut off all of your existing Medicaid funds. And so nobody really thought that the states would possibly be in a position to turn down all that Medicaid funding. And by parallel reasoning, no one thought that the states would be able to say, no, we don't want this free federal money, it doesn't cost the states a dime, this free federal money going to our citizens to help them buy health insurance. No one thought that people could take the political heat of turning down this free federal money flowing into their state. But we'll never know what would have happened, because the IRS, reading a very clear statute that says you only get the subsidies if you run the exchanges, turned around and said, you get the subsidies regardless of whether you run the exchanges. So states quite sensibly said, look, if you offer me $100 to pick up your garbage and you offer me $100 if I don't have to pick up your garbage, I'll take the $100 and not pick up your garbage. So 36 states quite predictably said, no thanks, but no thanks, we'll move on. So the logic argument doesn't work very well. They keep saying, look, Congress wanted these subsidies to go to the exchanges. And of course that's true, but Congress wanted something else. Congress wanted the states to run the exchanges. And they thought they would get the best of both worlds. They would get both of those things if they made the subsidies conditional on the states running the exchanges. So it makes perfect sense. So we have plain language, a completely logical result, and the final argument that the government makes essentially along the lines of, well, why wasn't anybody holding press conferences during the passage of the act, issuing these threats to the states? If you don't run the exchanges, then we won't give you the subsidies. And I have two answers to that, one of which is Medicaid and the other one of which is Scott Brown. The Medicaid point is, there's nothing in the legislative history. I mean, it would be an incredibly dramatic act. The initial deal said every dime you have from Medicaid goes away if you don't expand your eligibility criteria. This would be a seismic shift in American policy. But you can scour the legislative history and the committee hearings, and nobody was holding press conferences threatening governors if they didn't do it, they'd have all these poor people without health care. And that's for the simple reason nobody really thought that the states were going to turn down the deal. So, and the way deals work is you put it in the statute and the states get to look at it. My second answer is Scott Brown. No one ever thought that this Senate bill was going to become the law. The House had a completely different approach. The House wasn't going to let states run the exchanges. It was going to have the federal government run all the exchanges. And the way this would normally work is all Baucus was doing in the Senate was putting in whatever anybody wanted into this bill so he could get to 60 votes. Scott Brown wins Massachusetts. They can't go to conference anymore, which is the way it typically works. The House and the Senate get together and come up with a whole new bill, and then you pass it again in the Senate. But if you'd done that, you would have needed 60 votes to repass it in the Senate. Since you could no longer get 60 votes, the House basically had to take all aspects of the Senate bill and make it law. So why wasn't there a whole lot of discussion of this? Because they never had the process that you would normally have where you would hash out these kinds of issues. So if we are a nation of laws and not of men, and if the language of statutes means something that binds the federal judiciary, I know that a lot of judges think you can ignore the language of the Constitution because it lives and grows and expands over 200 years. I haven't heard anybody say that a statute has grown in the 3 weeks since it's been implemented so that its language means the opposite of what it says. So this will really be a very straightforward litmus test for federal judges of all stripes to say whether or not they believe in law or they believe in the administration's policies trumping the laws. And hopefully this time, as opposed to last time, the rule of law will prevail. Thank you.
Thank you, Mr. Carvin. I think we're all rooting for you. So I want to speak about the Affordable Care Act and the exchanges from the employer perspective, and I'll start out with a quote from Press Secretary Jay Carney back in November, and that was that the administration made it clear throughout the effort to pass the Affordable Care Act and throughout the period that continues that the vast majority of the American people, including those who have insurance through their employers, will not see a change. That statement is absolutely incorrect. All employers have been impacted and will continue to be impacted by the Affordable Care Act. And many employers are looking for resourceful ways to deal with the regulations. And the exchanges are one of those ways that that allow employers additional options to ensure that their employees continue to be covered. First and foremost, all employers who have health insurance have been impacted by taxes and fees imposed by the law. Some began in 2013, but this month, 2 new taxes went into effect. The reinsurance fee of $63 per covered person, that means per covered employee, per covered spouse, and per covered child, affect all employer-sponsored plans. And the health insurance tax, which requires fully insured plans to pay a portion of an $8 billion with a B tax that's due in 2014 alone. These taxes amount to about a 4% increase for fully insured plans and about a 2.5% increase for self-funded plans just this year. Also starting in 2014, mandated plan design changes, go into effect. All plans can have no more than a 90-day waiting period. There are a number of employers, especially in high turnover industries, that historically have had a much longer waiting period, and that now has to change. Additionally, all non-grandfathered plans have to lower their out-of-pocket maximums to no more than $6,350 as an individual or $12,700 as a family. Employers have historically incrementally raised their deductible or their out-of-pocket maximum to help negate annual rate increases. That now has to go down and cannot exceed these caps. Also, small employers, those with fewer than 50 employees, who are not required to offer coverage, but if they do, they're subject to expanded benefits, non-grandfathered plans in particular. These include pediatric dental and vision, which is a new requirement, maternity coverage, even for employers with less than 15 employees who are not subject to the Federal Pregnancy Discrimination Act of 1978, and serious mental illness coverage, which was previously mandated by Texas law only for much larger employers. Also, small employers are generally limited to deductibles of no more than $2,000 for an individual or $4,000 for a family. Again, small employers especially have raised their deductibles incrementally over the years to help negate high rate increases. This now has to stop. And all these are great benefits, but they come at a price, higher premiums. Additionally, small employers are boxed in to selling to buying certain plans that meet metal levels and strict actuarial values. And finally, the pricing structure for small employers has also changed. Adjusted community rating now requires that small employer plans be rated only on a 3-to-1 ratio for age. Historically in Texas, that's been much higher. So I'll give you an example. Let's say it was 6-to-1 last year. A 21-year-old would have a $100 rate. A 64-year-old would have a $600 rate. That's a 6-to-1 ratio. That's now illegal under the Affordable Care Act. It can be no more than a 3-to-1 ratio. Insurance carriers are going to keep their $600 rate for the 64-year-old. So that 21-year-old now has to pay a $200 rate rather than just $100. That is a significant increase and burden on small employer plans, especially for young and healthy, those with young and healthy employees. So as a result of these mandated benefits and pricing, our small group of business, block of business at MHBT, the average rate increase has doubled since last year to 23%. And additionally, we had about a handful of employers actually drop their plan as of January 1st. So the exchanges are a fallback to all of those employees. As time goes on, expect to see more employers take this option as rate increases continue to go up. Applicable large employers, those with 50 or more full-time equivalent employees, have their eye on 2015 and the employer's shared responsibility requirements. Of course, unless Mr. Carvin prevails, the responsibility is to either offer a compliant plan or pay a penalty, that is an excise tax. Many employers are going to continue to offer coverage for a number of reasons, but all options are on the table right now to look at reducing cost. The exchange, again, continues to be one of those options, or to be an alternative. Number one, plans are looking at excluding spouses from coverage, cutting back on employees' hours, offering what are considered bare bones or minimum essential coverage plans that basically just cover preventive care, dropping their plan altogether. And recently highlighted in the media was that self-funded plans are looking to, in a way, reverse cherry pick and look at their claims, their high claimants, and move those high claimants off the employer-sponsored plan over to the exchange. Therefore, the employer is no longer paying out all those high claims. Nothing in the Affordable Care Act expressly prohibits this, but this is probably the most controversial step to take. Now, we don't particularly endorse any of these concepts, and they do come with the possibility of a number of lawsuits that are based on existing federal laws like HIPAA, EEOC, ADA, and of course good old ERISA. But the thought of reducing cost is front and center on an employer's mind at all the time. Employers also have their eye on these premium tax credits that Mr. Carvin talked about, or the subsidies. There is the possibility that many employees at these employers can get a better deal or pay a lower price in the exchanges. For example, in Travis County, someone with an annual household income of just under $23,000, which is about 200% of the federal poverty level, a 27-year-old who gets the subsidy would only pay about $61 a month. A 50-year-old would only pay about $18 a month with the subsidy. And so costs are going to vary in other parts of Texas, and of course throughout the country. Some of them are even lower. But just to give you an example of what this plan will buy you, it is a $6,000 deductible and has a much smaller HMO network. So employers, both large and small, do need to weigh the benefits of maintaining an employer plan, like the ability to recruit and retain employees, having higher employee morale, peace of mind of knowing that their employees are covered by a comprehensive plan, versus the expense of that plan, the possibility of lawsuits if they pare it down, paying a penalty if not even offering the coverage, and the enticing possibility of lower premiums through the subsidies. So again, all employer-sponsored plans have been affected by the Affordable Care Act. Taxes, plan design changes have already cost employers. And next year, applicable large employers will be faced with the decision to either offer compliant plans or pay an excise tax unless the rule changes again. Even the employer who chooses to pay the penalty, even if the employer chooses to pay the penalty, at least the exchanges are a fallback to allow employees a place to purchase coverage. The exchanges have provided a viable alternative to employer-sponsored plans. Expect them to take advantage of it.
Commissioner F.
Good morning, everybody. When I got here, I'm having a wonderful time at TDI, but I see so many faces that I haven't seen in months, and I can't wait to say hello to all of you. So thank you for having me. It's fun to see so many people. When I got here, my chair is a little off kilter, but I found if I can lean to the right, I am stable, and I figure that worked for this room. I hope you laughed at that. So, with that being said, when Arlene Wolgemuth and John Davidson talked to me about talking to you about exchanges, I thought, well, that's going to be pretty short. TDI is not implementing the Affordable Care Act. We do not have the statutory authority to do it. And despite the discussion that we've heard a lot today, I really care what the statutes say. I mean, it's important to me that we follow state law. And so that's what we're doing. We do have the authority to implement Texas law. And so I want to talk about Texas law in connection with the Affordable Care Act for a few minutes. First of all, TDI will continue to monitor the Texas marketplace and the impact of the Affordable Care Act. I want to give you some statistics, but first, before we talk about the statistics, I don't think we're going to know the impact of the Affordable Care Act, at least for a couple of years. And so I've been asked, what do you think is going to be an impact for Texas businesses, Texas consumers, and Texas insurance industry? And I've had to tell people, I just don't have any idea. We're still watching to see what's going to happen. In the individual market, 29 carriers filed forms and 31 filed rates with us. But of those, 12 are actually offering plans on the marketplace within Texas. In the small group market, 24 filed forms and rates, but only 2 are offering plans in Texas. I think Texas businesses, the insurance industry, is taking a step back with a wait-and-see attitude to see if they want to participate. And so we are not seeing a very aggressive entrance into the federal exchange from Texas businesses. Then we're looking at the Texas health insurance pool. The legislature terminated the pool as of January 1st and gave the TDI commissioner the authority to extend that if need be. We did extend the life of the pool through March 31st, 2014 to coincide with the end of the enrollment period under the federal exchanges. And we do have a rule outstanding, and I want to encourage anybody to look at that rule and comment if you're interested in that, because it does contain options for extending the pool even farther. I do think that the goal for our agency was to protect the people who are in the pool who, because of confusion in the marketplace, were not able to obtain additional coverage outside of the pool. It may be cheaper for people to get coverage in the private market. It may be easier for them to get access through the exchange, but for some reason or another, and often because people were seriously ill, they were not able to do so. So we felt that it was prudent to extend the pool to March 31st in light of slower implementation of the Affordable Care Act than we were thinking would be the case. So we are in that process of considering the appropriate way to extend that pool even farther if we need to. I would like your input on that if possible. One interesting thing to note that we're seeing a little bit of growth in the insurance market is in existing Medicaid HMOs that are changing their business model slightly to offer their plans on the exchange or the commercial market. So that's one area where we've seen a little growth in businesses stepping out of their normal routine and expanding. Next, I want to make some comments about the exchanges and navigators. As you're aware, the Texas leadership and the legislature made it perfectly clear that we were not to implement an exchange or the Affordable Care Act. But there has been some confusion in comments that we received from the agency. People seem to not understand that the exchange operates like an e-marketplace, an electronic marketplace. It is not insurance, so we would not have the authority to regulate that exchange anyway. We have no authority with the exchange or the operations. Those are all federal. That being said, the Affordable Care Act also creates navigators to help people access the exchange. And pursuant to legislation passed last session, Senate Bill 1795, TDI does have the authority to regulate navigators. We have gone through the process of looking for protections that we think need to be in place to protect Texas consumers from the few bad actors in the navigator marketplace. And so we looked at the federal rules that came out in July. We've talked to federal HHS, and we are working through the process of determining what we would need to do in order to better protect Texas consumers, most specifically against identity theft. We posted an outline of concerns. We've had 2 public hearings, and we've come up with some requirements and some prohibitions. Those requirements and prohibitions were probably far more eloquently expressed by Senator Taylor yesterday, but I'm going to go through them real quickly again. Thanks, Gary. And our common sense rules would require proof of U.S. citizenship or immigration status to obtain employment in the United States, documentation of compliance with education requirements, training, fingerprinting and background checks, and evidence of financial responsibility to protect individuals against wrongful acts. In addition, navigators would be prohibited from the following. They can't charge consumers for providing information about health coverage. They can't sell, solicit, or negotiate health insurance coverage. They can't recommend a specific health benefit plan, but they can talk to an individual about which plan would be best for them. They can't provide advice regarding substantive benefits or comparison benefits of different health plans. And this is where we're working on the language to provide some clarity in our rules. They cannot engage in electioneering activities or financing or otherwise supporting the candidacy of an individual for government positions. Under the proposed rules, the Texas Insurance Code provisions related to privacy and protection of personal information would also apply to navigators. So generally, that's what we're trying to do, is protect Texas consumers. We had a close of comment period on January 6th, and we received well over 180 pages of comments and over 5 hours of public testimony. And so we are in the process of reading all of that. Our staff and I are, and working through the changes that we need to make in our rules. So people have said, when are they going to be effective? Well, we're working on it. So that's the best information I can provide you at this time. And with that as the backdrop, I'd like to step back and talk about TDI's role in promoting the safety, stability, and competition in the Texas insurance market. Despite the fact that I admit to people quietly that I'm a bureaucrat, I have worked for state government for 23 years now, and I'm a little embarrassed to admit it in this group, but I don't believe that government should be all things to all people and expanded to beyond the protections that are clearly specified in law. TDI, like other insurance departments, is the primary regulator of carrier financial responsibility, which is how we ensure that consumers receive the services that they purchase. We are interested in doing what we can to make sure that we expand the marketplace. I really believe that a highly competitive market is better for consumers and better for businesses alike. And so to that end, we are trying to promote the Texas marketplace, bring more Texas industry here. We've worked with the captive companies to redomesticate. We got new legislation last session. We are aggressively trying to bring more people into our marketplace because we believe that it's the best thing for Texas and businesses. In addition, we will continue to address consumer complaints and fight insurance fraud. We are trying to make sure that our agency is relevant in following the law at all times. And with that, I'll close and hope that you're nice to us and questions.
We're going to open up to questions, but because I'm moderating the panel, I get to ask the first question. And this is a question that any one of the three of you can jump into. There's been legislation that's been introduced in Ohio and Missouri, I believe, that is pending, that is in the process of being debated and going through their respective legislatures, that in light of the lawsuits such as Halbig versus Sebelius and Pruitt and the others, would suspend the licenses of insurance companies or restrict their license to issue new business in those states if they received subsidies and tax credits from the federal government. So my question is this scheme, is this a state action, the kind of thing that that would be plausible under the regime of the Affordable Care Act? Is this something that would be in harmony with what we perceive to be congressional intent in the law, or does this run into conflict preemption laws and would not really be a viable path forward for states to ensure that their federally created, federally facilitated marketplaces are in compliance with the law. I'm just interested if you, Mr. Carpenter, perhaps have insight into those measures and those laws that are being proposed in those two states right now.
Yeah, no, truth is, I hadn't heard about these laws. I think, frankly, you've put your finger on the legal issue. If the federal law really did authorize these subsidies, and then the state law came and put a cognizable obstacle like this to getting the subsidies, to issuing the subsidies, I think it'd be relatively straightforward that that is preempted. The state law is inferior to the federal law and would be knocked out. But since federal law in 36 states doesn't require this, and I'm pretty sure Ohio and Missouri are two of those states, then sure, they'd be just stopping a lawless act. So actually, any challenges, preemption challenges, if these laws were passed, would give you another vehicle for arguing that the government is misinterpreting the plain language of the act. In other words, the preemption argument would turn on the fact that federal law requires subsidies when the reality is federal law prohibits these subsidies.
Great. Let's have right up here in the front.
Check. There we go. If Mr. Carvin, your lawsuit is successful and subsidies no longer flow to the 36 states, it would seem to me that since the regulations regarding pricing, such as guaranteed issue and community ratings, would still stand, that the relative value of violating the individual mandate would become higher to people because they no longer have the subsidies that are mitigating the high cost of insurance. Would you expect to see a mini death spiral as a result of that? And if so, how could we mitigate the damage of that?
Right. So, look, there's a number of things that could happen in the wake of the lawsuit. But if the status quo continued in those 36 states, you're entirely right. There would be a very substantial chunk of the people on the exchange who are absolutely necessary to make the exchanges work, from roughly, say, 23,000, family of four, up to like 90,000 who are eligible for the subsidies. If they can't get the subsidies, then they can't afford this insurance. Federal law says, we don't care, go buy the insurance. So the first thing that would happen is there's a hardship exemption for the individual mandate. My guess would be the HHS secretary would be obliged to say, look, since the scheme contemplated you'd be buying this insurance with federal subsidies, since we're no longer giving you these subsidies, we're going to exempt you from the mandate. But that's, who knows what could happen. The other two consequences, to slightly shift focus, would be now states would be offered this deal. They would, so you might well get a lot of politics in states saying, well, let's go ahead and run the exchanges because then we get all these subsidies flowing into us. And closely related to that would, of course, be that the administration, I think, would feel some obligation to go back to Congress and figure out if they could fix these laws. So you'd have three moving parts at the same time in the wake of this lawsuit. You'd have Congress, with presumably at least one house controlled by the Republicans, saying, I'm not changing anything until you change a lot. You'd get a whole new renegotiation, I think, of partially or wholly repealing ObamaCare. You'd have the states being poised with this issue, should I really turn down running the exchange because it's going to cost my state a lot of money? But they'll be saying, well, let's see what happens in Congress. And then you'll have the HHS secretary dealing with millions of Americans who are now caught in this dilemma where they're, and of course, by the time these cases get decided, these people have already signed up for their contracts. I mean, they will, sometimes it works that usually these premium tax credits are sent directly from the Treasury to the insurer, like the customer never even sees this exchange. So you'll have people trying to unwind. There'll be a lot of pressure on the insurance companies. Well, can you continue me on the policy for at least a few months till I can transition to another policy, which is a shorthanded way of saying it'll be an ungodly mess. And I think there'll be a lot of activity. In my mind, as somebody who, this is no surprise, doesn't support the Affordable Care Act, that's all good, because the administration's been in a position where they can just resist legislative changes and threaten to veto anything that does alter the act. They won't be able to continue to play that game because I think every sensible person will recognize that we need to make some fundamental change. So at a minimum, I think you'll start some serious horse trading, would be my guess.
Yeah, right. Mr. Carvin, I'd just like to, question, Mr.
Marvin, about the actual consequences of the, if you prevail with your lawsuit. What would happen to those people and their subsidies if they've, the horse has left the barn, right? What are some of the things that could be done to deal with the aftermath? And do you think the consequences are weighing heavily on the federal judges' decisions when they make a ruling?
Yeah, I'll start with your last question. Sure, it's the elephant in the room or the 600-pound gorilla, whatever you want to call it. How can I do this and create all this chaos? The short answer to that is you didn't create the chaos. Congress did this, and really the IRS did it. If we had this, the IRS wrote their rule 2.5 years ago. If they had made it clear to everybody that this was the deal that Congress put in the act, then we wouldn't have had to do everything after the fact. So you really can't listen to the administration. It's not unlike, the orphan saying, I'm entitled to sympathy as an orphan because I killed both of my parents, right? Well, maybe not really. You're the one who created this mess, and the political process is the one. And normally we're worried about interpreting constitutional provisions in a way that create unsound policy consequences, but normally you're not in terms of statutes, because the notion is, well, if people think, if the executive and legislative branches think this is a bad consequence, then they can change it overnight. What I think will happen is sort of what I just said, which is I think you'll get a dialogue going between the administration and Congress, trying to figure out if there are some ways of working out of this. I think the difficult issues for the people involved will be sort of what happens in the interim. Technically, they have to give the subsidies back under the way the act is written. If a subsidy is illegally given to you, you are obliged to return it. I don't think the Obama administration is going to start suing millions of Americans to say, give us the subsidies, give us the money back for the money we illegally gave to you. So I don't think anybody's going to actually have to give the money back, but there is going to be this very knotty issue of, well, what do I do for my insurance for the next 6 months while all this is getting hashed out? And frankly, your guess is as good as mine on how that's going to work out.
And I think it's worth mentioning, too, to the question of giving the subsidies back, a lot of people don't realize that it is part of the Affordable Care Act that if you receive a subsidy for your health insurance and your income changes over the course of the year and you earn more, you earn enough to disqualify you for receiving that subsidy, you have to return the subsidy. You have to pay it back.
I'm sorry.
Yeah,
No, I just want to
ahead.
footnote that with two anecdotes. One is, we have a guy named Klemenchik who's in the Halbig case, along with Ms. Rumpf, who's a plaintiff. And so they had the head of, this literally the deputy secretary at HHS, entered 3 different affidavits within 2 weeks of each other telling you what Klemenchik's subsidies were going to be, all of them dramatically different. So the guy who runs this agency couldn't figure out what our plaintiff made. So it's like a Rubik's Cube just to figure it out if your income stays exactly the same. But to John's point, your subsidies are based on your projected income. But if your actual income exceeds your projected income, you've got to send it back. Well, for example, Mr. Klemenchik, I mean, he does floors. He carpets floors. Last year he made $20,000, but he's hoping to make $25,000 this year. And so once you buy into this system, then you are really running a very serious risk that they're going to come after you. Since the one hallmark of the Obama administration's implementation of this law is they're not really taking enforcement very seriously, I don't know how that'll play out. But what you're going to have in the spring of 2015, it's important to understand, is all kinds of people for the first time finding out that they have to pay the so-called tax penalty for not complying with the individual mandate, only when they filed their tax returns in April 2015. And then all kinds of other people are going to be finding out that, no, you actually need to send some money back for this deal that we've already approved. So I wish congressional elections were in April of 2015, But I think you're going to start seeing some of this even prior to that.
Yeah, and so that element of risk, that people are actually taking on substantial risk by accepting subsidies, isn't something I think that's widely understood about the.
Well, think about the people eligible. I know I made this point, but you can have pretty wide variations, and this formula is so complicated. Like $2,000-3,000 can make an enormous difference. You were pointing out what a 57-year-old versus a 27-year-old versus a 50-year-old. What, 18 versus $61 a month? I mean, this is real money, and it's subject to this stuff that I literally don't think anybody understands. And so it's any tiny variation can have a huge impact on people of relatively modest means incomes.
Yeah. We had a question back by the camera over there.
Good morning. First, I'd like to commend the panel on how well you conducted that and keeping it on the facts. And it's agreeable that it's a lot of things going wrong with the Affordable Health Care Act. But my question is, okay, so I'm a social worker, so I'm a bleeding heart. How do we I hear a lot of people talking about it, but what are some remedies to address the more than millions of people who don't have health care, where we can move Texas from 49 up the ladder, that we're taking care of our people?
Well, we have some ideas at the Texas Public Policy Foundation. This is actually a good time to point out the exchanges. When the exchanges were put into the Affordable Care Act, they were actually put in. Although the law that it ended up passing was not supported by any Republicans, it didn't get a single Republican vote. When they were putting the law together, there were elements of the law that were meant to kind of be an olive branch. They were meant to be compromises. They were meant to be market-based apparatuses in the government, or in that the Democrats put into the law. Some of which were based on Massachusetts healthcare reform, the ObamaCare, which included a mandate, which included the exchanges. There's a way for exchanges to be market-driven and for them to work to provide people with coverage that would substantially move the needle in a place like Texas and help more people get coverage who just don't have it available to them through their employers right now. However, the quite draconian regulations that have accompanied these exchanges have made it not only a very unattractive proposition for states to set up and run the exchanges, but a very risky proposition for people to actually enter the exchanges and accept these subsidies. The plans themselves, as Becky was pointing out, are so minutely regulated that the exchanges are really nothing more than a mechanism to deliver a standardized insurance product. That's why states have no incentive to set up and pay for exchanges, and that's why we see sort of tepid participation on the part of insurance companies themselves, not only in Texas, but in other places. However, and this is not just me saying this, a lot of other people who are smarter than me have proposed this. If we were to deregulate the exchanges, and this may be part of the horse trading that might result in Congress if Mr. Carvin and his colleagues prevail, one of the changes that would be possible is to deregulate the exchanges entirely, allow insurance companies to offer any kind of plan on the exchange that they want with any deductible, essentially make the exchanges true clearinghouses for insurance, so that an individual who doesn't have insurance offered through their work, and there's a lot of industries in Texas especially that don't offer insurance, the restaurant industry, construction, a lot of people just don't have an offer of insurance from employers. If there was a mechanism by which they could go to an exchange and choose from among many, many different kinds of plans that had many different features to them, catastrophic coverage with HSAs, high deductible plans, there's a real chance that we could see the insurance, the uninsured rate change in Texas. However, that's going to take a congressional change to how these exchanges are structured so that they actually perform a market function rather than really performing an administrative and bureaucratic function right now, which is the very reason you don't see the participation. And among young people, you won't see the participation either. We've distributed a paper that shows just how much more expensive insurance is on the exchange than it was prior to the exchange. And I think that's one of the things you were pointing out. For young people, it's a losing proposition. Young people have no incentive to go onto these exchanges and seek coverage. There are ways to work with the Affordable Care Act, to work within the structure that's there, but it's going to take changes. We're going to have to roll back the parts of it that are preventing market forces to come into play.
Just to footnote that last point, and this was our major point during the constitutional challenge to the act, which is all these young people were being scapegoated as somehow free riders who weren't paying their fair share of insurance. Well, you're a healthy 28-year-old. The only insurance that makes any sense to you is catastrophic, right? Because there's no way in the world that it won't be cheaper to pay for your, I didn't go to the doctor for 20 years, I'm not holding myself out as a model, but there's no way that you can't pay for your relatively infrequent doctor's visits, absent a catastrophe, that it won't be a lot cheaper for you than paying for especially grossly, ever increasingly expensive insurance. The relevant point is that if you allowed people to buy insurance that actually suits their needs, like catastrophic for a healthy person and not require 70-year-olds to buy maternity benefits, then you could have some real pricing. But that was a conscious choice by Congress. They deliberately made young or healthy people buy a lot more insurance than they would ever need on an actuarial basis so that they could subsidize the sick people who are paying obviously less. This is the 3-to-1 ratio and these other things that we were talking about. So if you wanted something, even if it was not completely deregulated, at least something that allows people to buy the kind of insurance that's relevant to them as opposed to subsidizing others would go a long way to solving this problem.
And unfortunately, I think I've been given the signal that we're out of time. But join me again in thanking our panelists for coming out today.
Thanks. That was fun. So you're going to be at the tail.